agree to a rule like this one, which sort of makes this question of do you have to show you would win or do you have to show margin of victory a little bit irrelevant, that what you have to show something. It's not enough to just walk in and say, hi, I'm a candidate and I'm suing. But what you have to show is some kind of substantial risk or substantial likelihood, whatever the phrase may be from our standing doctrine, that the new rule puts you at an electoral disadvantage relative to the old rule. So that, if the new rule says more mail-in ballots, then you just have to plead that that's a kind of rule that puts you to an electoral disadvantage. And say something, not a lot, but something to suggest that that's right.
So I could live with that rule. I don't know that it's the ideal rule. I mean, I'm not coming in here asking for a broad rule because I'd like to win this case in the hardest possible way. I'm asking for that because I actually see advantages to it, namely that even under your view, you still, in theory, would have at the summary judgment stage this debate in Article III courts about whether late arriving ballots help Republican candidates or Democratic candidates. And that makes me sufficiently uncomfortable that I actually would prefer a rule that says, no, Congressman Bost is coming in and he's saying there are going to be unlawful votes cast and there'll be ballots with his name on it in his election. That's enough. We're done. None of these.
I mean, your rule really does just take out the injury requirement entirely. It just says you should assume that if a candidate is there before the court, the candidate has good reasons for being there before the court. And for the most part, I think we have rejected that view of standing. I mean, for example, we said there's no such thing as doctor standing just a couple of years ago. So too here, it seems quite inconsistent with our standing law to say, oh, we just have an automatic rule for candidate standing. On the other hand, I'm sort of in sympathy with the view that this bar should not be all that high and that the bar shouldn't have to, you shouldn't have to say, here are the polls that show I could lose as a result of this rule. It's all you have to do is come in and say why it is that the rule puts you at a disadvantage relative to what's come before.
So, Justice Kagan, I don't think that much separates us. And so I don't want to sort of die on any particular hill here. The reason that I'm hedging a little bit, I'll say two things in response. One is, I don't think we're saying get rid of the the injury in fact requirement. We're just saying unlawful ballots being counted in your election is an injury in fact. It's a little abstract, sure, but it is an injury in fact. And then everything else follows, and then you don't even have to get into what I still think is an uncomfortable prospect of competing expert affidavits where one party says that actually late-breaking votes can actually be good for Congressman Bost because people like candidates with a B in their name or something, and then the other side says, no, they're actually good for the Republicans.
Mr. Clemento,